Good afternoon. Welcome to another edition of Legal Access. We get together once a week to give you access to different aspects of the law. Today we're going to be talking about what's called premises liability, which is just a fancy way of saying if you get hurt on somebody else's property, who is liable for what and what you need to do in case that happens. A lot of people associate slip and fall accidents with that, which they are part of that. But if you have any questions along this line, make sure and give us a call. Numbers on your screen, 848-8080. We'll be happy to answer those questions for you here today on Legal Access. On our panel to answer those questions from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
And also to your left at the end of the table, Josh Koshin.
Thanks for having me again.
Great to have Josh back. And as you can see, we have an empty seat. And it was going to be Tiffany from our office. She's stuck in a deposition. And Rick was going to come, right, Josh? And he's in mediation, but I think he's on his way, so that's why we're holding the seat for him. But it's great to have Josh with us, and as you said, this is a premises liability show, and Josh, I know your firm, as we do, handle these type of cases. I know you also do automobile wrecks, and you do some criminal defense, and of course workers' compensation.
That's right. Mm-hmm.
Anything else that I'm leaving out?
I mean, we kind of tell everybody, hey, just call us if you need anything. If we don't do it, we probably know somebody who does. So. But those are the main ones.
Yeah. And that's a good way to, that way at least people can get routed to a law firm that handles that type of case. So we sort of do it the same way.
Right.
But of course the topic today, Dave, as you mentioned, is premises, and it does encompass various types of cases. Everything from violent crime on a premises to falls on a premises. So there's cases where there's with alcohol where we have called dram shop cases. So there's different types of cases with premises, and what they have in common is if somebody's injured on the premises, there's a potential for a case. So if you own a company and you have questions regarding that, or if you have or family member's been injured, you just have questions, give us a call at 843-848-8080. And again, our topic is premises liability.
I keep looking at the empty chair, and I think we're playing like musical chairs. Whatever lawyer comes in first and gets into the chair, that'll be our next guest there. You mentioned dram shop cases as far as alcohol liability is concerned, and I know one of the things that's been a big issue on our State House in South Carolina here recently has been the insurance rates for some of the businesses that do serve alcohol, and thinking that it's way out of their ability to pay for it anymore. I mean, is anything going to be done about that, or is there going to be any movement to save the small businesses as far as being able to pay for their insurance?
Yeah, and I think we had similar issues years back with workers' comp, and when they really got to the root of it, it was more an insurance company issue than it was, and it was sort of straightened out when they. And I suspect it's the same type of thing is going to happen. Although maybe we'll get one of our senators, our representatives on, and we usually once or twice a year do a show with local politicians that sort of can answer those questions better than we can. But, unfortunately, when you have these dram shop cases, it's usually because there's a very serious injury or death resulting from drinking and driving, and it really is looking out for the safety of the community to make sure that those that are serving alcohol and making money serving alcohol are doing it in a responsible fashion. So the last thing you want to do is do anything to take that pressure away, right, Josh?
Yeah, and I think these dram shop cases are really a deterrent and a warning to establishments that serve liquor and alcohol that you got to be careful when you're serving it to people. Mm-hmm. Don't over serve them to the point they become intoxicated, get in a vehicle, and then go and seriously hurt or kill somebody. So there's definitely a strong movement in the legislature among a lot of small business owners and other business owners who carry liquor liability insurance to maybe kind of tame some of the rules. I mean, the law now basically says if you serve liquor that you have to carry $1 million insurance policy. Right. So obviously the premiums for that can skyrocket and get high and make the bottom line of businesses hurt at times at the end of the year. So, but I think just like in any business or in any law, there has
Right.
to be some kind of happy medium, happy balance to make everyone happy.
The general public who has heard about some of these cases get a little bit confused, though, and concerned, because if somebody goes out for breakfast and has a mimosa for breakfast, and then 12 hours later they get into an accident, that they can go back to that breakfast place and say, yeah, they started their drinking at this place and had a mimosa, they need to be held responsible in this case as well.
Yeah, that's, there was a judge who's long since passed, but he'd always reach out to the jury veneer and say, anybody can file a lawsuit. And as a plaintiff's attorney, it's not a good way to start, but it's the truth. Anybody can file a lawsuit. But there are rules, and it is difficult. There's a burden of proof that has to be met in these cases. So you're not going to have a mimosa, serve somebody a mimosa, and then hours later have an accident. Somebody could file a lawsuit. It would be frivolous to do that,
Right.
and I wouldn't encourage anybody to do that. But there's also cases where bartenders are giving people shots, and when they're already inebriated and intoxicated, and different things like that, and putting innocent people in danger. So we want to do our best to make sure that doesn't happen and keep everybody safe.
Well, Josh, as you were talking about keeping their patrons safe at a bar and making sure that they're not being overserved, but keeping patrons safe is a big thing, and that's why a lot of talk has been recently is making sure that there's security at not bars, but security at just about anywhere where there's going to be patrons, whether it's a retail store or otherwise, to make sure that nothing happens to the patrons or the clients that come in. Is that something that is being a little bit more common as far as looking at lawsuits if people get injured in a store because of maybe somebody coming in and robbing the store and leaving people injured?
Yeah, so I mean, obviously it's going to come down to one of the big rules in premises liability cases is, did the defendant or the business owner, did they have notice? So if they knew they were going to have a large number of people and that there could be some kind of violent situation, are they in a high crime area? Are they prone to incidents where security would be an issue? If they had notice of that, then they certainly can be liable. So obviously, as a business owner, there are laws, but then there are best practices. So I think any business who's dealing with a large number of people, or maybe maybe not the best clientele or customers that come in who could be rowdy and get too intoxicated,
Right.
or whatever, cause problems, that they should talk to maybe a security professional or consultant on the best practices to keep their business safe and their patrons.
And we always use the words, and you've heard it over and over, Dave, is reasonableness and foreseeability, right? So if it's foreseeable, you're in a high crime area and you have a business and you're making money off the public, you have a duty to keep the premise in a reasonably safe condition. And there's no simple cut and dry rule, black and white rule to a lot of this. It's
Right.
going to be a case by case basis, and that's why people call and we joke that we sound like lawyers, right? But it really you have to have all the facts to make determinations, and sometimes there's going to be differing opinions on what's reasonable and not, and what's not reasonable. But we want the public, and we want
Right.
our citizens to be safe, and at the same time, we don't want to put an unreasonable burden on people that own businesses either. There's something, as Josh said, something where it's you try to balance the reasonableness, right?
And being kept safe inside the business is one thing, but what about the premises outside, parking lots and et cetera?
Well, people are coming on your premises, and they're coming on the premises for the benefit as an invitee of the business. Then certainly there's a duty to keep the outside of your premises safe. Whether that's cameras, whether that's as a deterrent, whether it's having security guards, if entering an establishment that, there's a history of violence of any kind, then you'd want to maybe have some kind of assurances that people aren't coming in with weapons. So there's different things for different cases, but it all comes back to foreseeability and reasonableness.
Tell you what, we're going to run to a break right now. If you have any questions about premises liability, slip and fall accidents, if you've been hurt on somebody else's premises, give us a call. We'll give you an answer. 848-8080 is our phone number. Coming up after this break, we'll find out what the steps are to follow in case you have been hurt on somebody else's premises. That's coming up in just a second, plus your phone calls right here on Legal Access. Welcome back to Legal Access. The phone lines are open if you'd like to give us a call. Our subject today here is premises liability if you've been hurt on somebody else's premises, or if you're a manager or an owner of a business and you want to know what you should do in case somebody gets hurt on your premises. Today is the show to give us a call. The phone number is on your screen, like I said, 848-8080. Give us a call. We'll get you on the air here. Now, as far as steps to follow, as I mentioned before the break, if you are on somebody else's premises, and I'll just use the biggest example, if you go to a big box store and you slip and fall in the aisle because of something that you stepped on that's there, and what should you do if you're the person who falls? What's the first steps that you need to do to make sure that everything is moving forward?
Well, if there's any chance that you might be injured, I would let the manager or owner or whoever, of the establishment know what happened. And usually there's protocol where there'll be an incident report that gets filled out. I would definitely do that. Most things nowadays there's video, so I would do whatever I could to make sure that that video is preserved. Lawyers, we call it a spoliation letter that we send out saying, keep everything that because on the date of this incident, it's just the smart thing to do is and the fair thing to do is let the premises owners or managers know what happened and what's going on.
Should you whip out your phone and start taking pictures of the situation?
In the old days, people would say, "Oh my gosh, that's so litigious." I think nowadays, I would say yes. The people expect, most everyone has a phone and is able to do that. So it's almost like if there's no video, the question is why not, right?
Right. I mean, another thing you got to think about is, I talked earlier about notice. So, I mean, if you have water and there was on the floor and you slip and fall on it, but you're at a grocery store and the person in front of you had a kid and spilled drink on the floor and then you just happen to step on it right after.
Right.
How is that the business's fault? How are they on notice? How would they be able to clean that up in time before you'd even approach it? So, I mean, I would say even if you're not hurt, report it to somebody. You don't want anyone else to fall.
Sure.
Just fall and take a little slip and then whatever, you're okay, still report it and get it cleaned up. But I would say, most people are going to the store, going to the establishments, and they have people with them. So, I mean, if you're too severely hurt to do anything, have somebody else take a picture.
Yeah, 100%.
If you feel like you need to go to the doctor or a hospital, but the manager doesn't offer that, should you just go ahead and go and keep track of that yourself?
Absolutely. And, if not every case, every time somebody's injured on a property, like Josh says, that doesn't necessarily mean that the premises owner is responsible.
Right.
We always use the same example. If Dave's walking down the aisle and spills his water and I come a few seconds or minutes later and slip on that water, it's not necessarily going to be the premises owner's responsibility. But even in those cases, most establishments have some no-fault insurance that probably can pay for your medical bills that you incur up to a certain amount, and even sometimes lost wages that you incur. So it's always smart, beneficial to contact the insurance company of the premises and see what can get worked out. I wouldn't give any recorded statements or anything like that without talking to a lawyer, though. I think that's the only risk of getting in touch with the insurance company without discussing it with an attorney first, right?
Right, I agree.
There's one big box store that I go to that they've got like markings and big X's on the floor because they know that every time it rains, that's where they need to put the buckets and the trash cans because it's going to leak right there. So, I mean, that indicates to me that they know that there's going to be a problem every time it rains. So if I slipped and fell in that area, I'd be able to say, hey, they know that there's a problem, but they didn't fix it.
Yeah, 100%. Yeah.
So later on this evening when
They
it
sort of
starts
sent you a
raining-
letter
yeah.
and said, hey, here.
Yeah.
That would, in the lawyer industry, that's what we would call Exhibit A. Picture of that.
Yeah. And, you know, a lot of times the negligence is the premises owners are aware of an issue and they just don't give proper warning or you know, do what's necessary to keep it safe once they have knowledge. You know, they mop a floor and they don't put cones down, or they put cones down in the wrong area.
Right.
So people are looking that way, and the cones actually should be blocking the aisle
Right.
that they're walking into. So a lot of times it's just simple stuff that, you know, it's just taking time to be careful.
Yeah, and I think something that you learn in law school when you're covering premises liability in your first year torts class is you have this little test that you can use even as lawyers today if you go to a trial or do litigation. It's safety versus utility, you know. How dangerous was the situation versus how much would it have cost for the business owner to repair that? So
Right.
in instances where you have orange cones or warning signs or something like that, those things are relatively inexpensive. So, you know, typically, you know,
Right.
if you're on the plaintiff side and you're advocating for the injured individual, you would say, hey, you know, the business cared more about profit and
Right.
not spending a little bit of money over the safety of their patrons.
Where security guards may, for a small business, be something that
More
that might be
expensive.
More
Right.
expensive. So
Right.
it really goes. On the other hand, if you have a mall or something where you should have security, you want to
Sure.
have proper security. So it really depends. And I think Josh gave a great example, and that really, like he said, to this day is how you balance it. You know, it really is.
If you have any questions about premises liability, give us a call. The phone number's on your screen, 848-8080. We do have a couple of people on hold right now. If you're on hold, stay right there. We'll get to you in just a second. We do have to run to a break here first, though, on Legal Access. And we're back. It's Legal Access. Give us a call if you have any questions about premises liability, if you've been hurt on somebody else's premises, or if you're a manager or a business owner and you want to know what you should do if somebody does get hurt on your premises. Today's the day to give us a call. On our panel to answer your questions from the McGuire Law Firm is Ian McGuire. Also from the O'Neill Law Firm is Josh Koshin. So thanks for being here today. And again, I want to thank Susan from Florence for hanging on the phone line during the break. Susan, hi. Thanks for calling in. What's your question today?
My question is, if a church were to allow a group, for instance, an AA group, to have meetings in their facility, does the church's liability insurance cover that group, or does that group have to get their own insurance, or could the group members possibly sign a waiver that would release the church from any responsibility should an accident occur?
Yeah, I mean, I think I would explore all of those avenues, check and see if the church's liability insurance policy would cover something like that. Also, whoever's organizing the group and that's coming to the church, maybe you ask them to provide some kind of certificate of insurance that if anything happens on your premises, that it would cover any injuries or anything like that. And I'm sorry, your third question
The
was?
third was, could they sign a waiver?
Sign a waiver.
Saying, yeah, I mean, you certainly could do that. You know, the problem with that is that if somebody was to get injured, they're probably going to file suit against wherever the insurance is. So although it may work in a sense, it's something I'd be a little careful doing. I'd just make sure that there's insurance, and that whether it's the group coming in having insurance or making sure the insurance covers you know, different groups that are using the church grounds.
Right. Right.
Because, yeah, what ends up, I think a waiver might be fine between the two parties, but the injured person is going to be less,
Right.
interested in the waiver. They're going to probably file a claim against both establishments if there's a question about insurance. So the most important thing is just make sure that there is insurance on the premises and that it's not being excluded if for the people using the premises.
Speaking of signing waivers, here along the Grand Strand, there's a lot of people who go out to some of our amusement rides and they'll sign a waiver and make sure that, if anything happens to me while I'm out on the banana boat or on the jet ski, that I'm not going to be holding the business responsible who rented that to me or who's taking me out there. Do those waiver forms sign away your rights if you do sign something like that?
Potentially. South Carolina has a couple of cases that are not great for injured people that sign waivers, and the truth is even lawyers will be going to do something fun and they'll see all this boilerplate language and you're signing it. You can't waive gross negligence. So what happens in those cases, the quick answer is yes, it can impede your ability to make a claim, but if it's gross negligence, the waiver is not going to excuse that. So there potentially be a case anyway, but it does offer some protection in South Carolina, the way the law reads right.
As far as amusements are concerned, we've had a couple of incidents here along the Grand Strand over the past 6 to 8 months as far as pools are concerned and as far as children being injured in pools. Some I think have resulted in death, unfortunately, but if somebody goes to a pool at a resort and there's a big sign up there that says, warning, no lifeguard on duty, are they exonerated from any responsibility if something happens to anybody who's there?
No, not necessarily. I mean, it's nice to have the warning signs to protect not only your patrons, the parents, the children, to let them know, hey, monitor your children maybe a little bit more closely than you usually would. But I think it again goes back to were you on notice of having a large amount of people coming to your premises to swim in your pools, and was it you have to weigh the cost for the benefits of having security or lifeguards there to make sure that everyone's safe versus how much is that going to cost you?
There's no exoneration by putting that word is really it's Josh said
it's more a criminal term of art.
And it comes down to case by case. The more you do as protect, especially children, the better off you're going to be. And our society is geared to protect children, and as we should. They're not in position to think as logically as they're grown up. That's the reason why you take whatever steps you can to make sure they're safe.
I'm sorry, go ahead, Josh.
I was going to say, I think it goes back to what you said in the first segment of the show, which is just be reasonable. What's foreseeable? How many people do you have? You don't have to hire 20 lifeguards for a 20 by 20 swimming pool, but it may be best to have at least one or two there at all times.
Conspicuous signs. I'm not saying that a jury might not find that you're responsible, but there's some risk to pools.
And we talked earlier about patrons being invited into businesses and stuff like that, and they've got a higher standard. Let's go to the other end of the standards, though. If somebody is trespassing on somebody's yard or somebody's property, if there's a sign up, that's one thing. But if they're trespassing just unbeknownst to them and they get injured one way or another, do they have any kind of a case?
Not unless there's like booby traps or something. Again, it's different with minors. We talk about it all the time. But if an adult is trespassing on property, it's going to be very difficult for them to recover unless there's something intentional.
I think in the law you really are looking at the classification of the injured person who's on the premises. So the law imposes the lowest duty on a premises owner on a trespasser versus, if you're Costco and you're inviting people onto your premises to, buy in bulk, then you owe a little bit higher of a duty to them.
Yep.
All right, tell you what, that's all the time that we have for our show here today. Definitely appreciate you watching here today. Make sure and keep it here on First Alert Weather throughout the course of the day and into the night to find out what's going to be happening as far as all the rain that we're going to be able to get tonight and tomorrow. Next week when we get together, we're going to be talking about workers' compensation. So if you have any questions about workers' comp, next week is the week for you. Make sure and tune in for that. And if you have any questions, we'll answer them next week right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does